Uh-oh, we're back with the one and only. It's James Murphy, MetaLawMan. They can't hold him down. Twitter couldn't hold him down. X couldn't hold him down. YouTube can't hold him down. He's back. How you doing, James?
I'm doing fantastic, Brad. So great to be with you. You always bring the energy. It brings the energy out of me as well, just to talk to you. And so it's been a while. Wonderful to be back on with you. And if you don't mind, I really would like to start with a thank you to you, as well as the XRP Army, in helping me get back on Twitter, both me and DAI, the digital asset investor. You know, we were in the penalty box for months, doing all of these appeals and getting no response of any kind. DAI was told that he is an imposter of himself. I was told they won't tell me what rule I had violated. And so that was a little frustrating. But anyway, so DAI and I together cooked up this plan. If I'm going to write this comprehensive letter of what we have been through and send it to Elon Musk, and then hopefully it would, perpetuate and propagate on the X platform. Well, that's where you came in. And so you absolutely took that thing and ran with it. And then you've got so many followers who then reposted and reposted. That letter that I wrote was viewed millions and millions of times. And shortly thereafter, DAI and I were reinstated on the X platform. And I want to thank you because you were kind of the first to pick up the baton and publicize this. You put it on your YouTube thing and read most of that long letter. And then, as I said, all of the wonderful people in the XRP Army who have been so wonderful to me, picked it up from there and propagated that thing, and it went everywhere. And I have to believe that was the cause of letting us back in. So thank you. Thank you to all your followers and the listeners of this program. That was really a wonderful gesture. And people say a lot of bad things about the environment within X and Twitter. And my experience has been just a tremendous amount of love and support, particularly from XRP holders. And so thank you, thank you, thank you.
Hey, James, thank you. You're such a big contributor to this space. And in this interim of all of this ambiguity and lack of clarity in this space, you, John Deaton, Jeremy Hogan, and so many others, James Filan, I can't even list them all. They know who they are. You as well have helped to guide us through all of these very, very difficult to understand cases. We would be lost without you. So it's, this is this thing goes back and forth, right? It's not one-sided at all. I was very glad to help. And I was very glad that the community kicked in and realized what was wrong. I've been victim of censorship over the years. I recently suffered a minor censorship issue with YouTube platform just because of something was on my thumbnail, right? Freedom of speech is not, it is an idea. It is not something that's active in this world right now, right?
Right.
It's quite scary, but we are glad that you're back. We're glad that the XRP GOAT is back himself, digital asset investor too. So glad that you guys connected, got to know each other. And we have a lot to go over today, James. I mean, we got topics. There's a lot of stuff in court, and the SEC has not been getting their way. We got Coinbase, we got Binance, we got the Ripple case, we got DebtBox case. Where you want to start here?
Well, I guess we can take Coinbase and Binance together. Those two hearings were just a few days apart, and both of them were the defendants were seeking to dismiss the case early. And I think people need to understand the way our legal system works. It's really, really hard to get a case dismissed at the beginning. And you, having followed Ripple, you know that. Garlinghouse and Larson attempted to get the case dismissed early and were unsuccessful, and then ultimately won on summary judgment. And so this is not an unusual course. I am hopeful, I'm optimistic that something very unusual might happen here, and one of the cases or the other gets dismissed, probably partially. So a partial victory early, hopefully. But the judges are very smart. but they're not expert in how crypto works. And so therefore, the SEC made a lot of statements that were not immediately challenged by the judges. Unfortunately, one of the best examples was one of the SEC lawyers in the Coinbase case said the reason that Bitcoin is not a security is because there is no ecosystem behind it, unlike all of the other tokens. So John Deaton and I, we're sitting next to each other in the audience there, and we just turned and looked at each other. And, you're not supposed to laugh in court. That can get you in trouble. But, our eyes were rolling like, how can they say something so absurd? And the problem is the judge didn't contest that. The judge doesn't know that, in fact, the Bitcoin ecosystem is one of the largest ecosystems on the planet and arguably is second only to the internet itself in terms of the scope of this ecosystem, where in order for transactions to be validated, there has to be a consensus that involves people and mining in nearly every country across the globe. That's an ecosystem. And then all this building that's happening on top of Bitcoin with ordinals and other things happening. There is no question that there is an ecosystem. And so really troubling kind of representations in Coinbase. The judge asked 3 times, is the token a security? And the first answer was no, the token itself is not a security, it's code. Then they changed the answer to say, well, yeah, the token embodies all of these promises. And so it really is, it embodies the security. And so then they shifted back later to saying, well, no, we're not saying it's the security. So it was inconsistent and contradictory, but the judge is not an expert in this. So that was a little troubling, and it wasn't easy to call the SEC on it because there wasn't this constant back and forth that you normally see in a hearing. It was 3 hours of questions for you, 2 hours of questions for you, and then we're pretty much done. And so I didn't come out of there with tremendous optimism in either case that it's going to be dismissed entirely right away. I remain highly confident that Coinbase will win its case in due course for a number of reasons. But the motion to dismiss is, it's going to be a close call how that goes.
And it is a serious thing to have a motion to dismiss. Like you said, it's not something to just take lightly, to assume that you could just go in on a whim, just get something thrown out. It is not an easy process to go through. So it does sound like, however, because I did listen to the Coinbase call-in, and oh my gosh, I mean, it was just remarkable that first 2 hours of the judge just putting the SEC on their heels. Just like, I mean, the questions really kind of exposed a deep understanding to a degree, right? The judge obviously allowed some things to be said that were like, whoa, what kind of willy-nilly stuff is this, right? I mean, because I'll tell you what it reminded me of when I heard the SEC take these split stances. It reminded me of acting in an unfaithful allegiance to the law, what was said from Judge Torres in the case with the SEC versus Ripple. And, we're seeing this over and over, James. Like this is the modus operandi. This is the way they're fighting crypto cases, which I'm standing here and saying it's this, then I stand here and say it's that, then I stand here and say, and depending on what case it's in, this is what they're doing. And I'll say this out loud. I mean, what it feels like to me is that this is how you get legal precedent set in these cases. But it feels dangerous because courts aren't supposed to legislate. And it feels like the SEC is trying to backdoor legislate this space through presidential findings and rulings in these cases that give them the ability to keep overreaching in this space. I happen to feel from where I'm standing that this is the shortfall of Congress and Capitol Hill not doing what they're sent there to do, which is to create legislation so we don't have to fall on the courts and some rogue agency acting under regulatory capture, I believe, and remarking these cases in a way that's trying to establish further ground for themselves. Your thoughts, James?
100% right, Brad. It is remarkable that we are at a level of dysfunction with our government that we cannot come up with a comprehensive regulatory regime. And I think there are a couple powerful forces standing in the way. But, if you look at it from an international context, I keep going back to, can you imagine 27 different countries in the European Union got together and agreed upon a comprehensive framework for regulating crypto. And so crypto companies from all over the world headed over there, including Coinbase, to set up shop. Why? Because they want to comply with the law. It's a lot more fun to operate a business when you know you're making money and complying with the law. Imagine that, Brad, 27 countries, they speak different languages, and they were able to come up with a comprehensive regulatory regime under that MiCA standard. Do I love it? No, I don't love it. But now you know what it is. It's in writing. You have hundreds of people doing compliance in all of these companies that their only job is to make sure the operation matches the regulation. We have none of that here. We have a lie. We have a lie from our securities regulator saying, oh, we have that here too. When we know in May of 2021, Gary Gensler testified. He didn't just say it to CNBC. He testified to Congress. There is no regulatory framework to regulate crypto exchanges, period, full stop. And now he says, you know what? On second thought, we got all of the authority we need. And I can't understand for the life of me why they don't come in and register. Well, the reason is there is no path to register. Coinbase can't come in and say, hey, we list all these tokens. We'd like to register. And they'd say, all of these tokens are unregistered securities. Get out of here. We want you to go to jail. It's not like, come on in, here's the form, sign it. It's ridiculous. So in any event, I get a little worked up about that because what is being said to courts is false on this score, and it's not right, And think about it. What if we had gone back in time? Into even 2018 or 2020, and the SEC decided to do something very, very different and said, we don't have this authority to regulate crypto assets or crypto asset exchanges, but we really think we are the best equipped to do it. And they constantly hit Capitol Hill to lobby for a set of regulations. You know what would have happened? We'd have a set of regulations right now.
Right. That's right.
And they didn't do it. Gary Gensler's first appearance in May 6, 2021, he said it. That was the right thing to say. He should have followed up and said, you know what? Not only that, we've drafted up something that we think would work in the crypto space. Here's a proposed, outline of legislation that we could get behind. None of that happened. And so they engage on this regulation by enforcement jihad, where they take different positions in different cases, contradicting themselves, trying to convince judges of things that are not correct under the law. And they're dealing with judges who are not experts in the topic, like you are, and like many other people are. And so they can make mistakes, when they hear, hey, there's no, unlike, Solana or whatever, there's no ecosystem in Bitcoin and Ethereum. It's crazy, but hopefully they don't get away with it for long.
I hope you're right too, and I do believe, even though we're going the long way around the mountain here, James, through the legal course of this and setting precedent, because it does appear to me to be that we're seeing these different precedents. The SEC is carefully choosing these cases, I believe, that represent different elements of this space, whether it be the kind of technology it is, whether it's consensus Byzantine algorithm, right? Like XRP or Ripple as a company, and XRP is separate, and that whole construct. I believe at some point we'll see a legal case against proof of stake company or token, and then eventually proof of work somehow. We already hear the teasings of this possibly, right? But what is really sad, to the point that you're making here, is that in acknowledging that the SEC did not have the power in testifying on Capitol Hill, as Gary Gensler did, and they don't have the power at the SEC to do what they're currently doing, they could have, as you said, followed up, issued what they considered a one-pager, a bullet point one-pager as guidance until it was passed as legislation, and Congress could have simply used that guidance as their framework to draft legislation. Look, I mean, I know you know this too, and I say this for the audience here. There's so many different levels of people's understanding in this space. You know, the technology is so young, and I can't even believe it. Like, one of the people that I really don't care for the way his tenure was at the SEC was Jay Clayton, but he actually said it best. You know, you can't avoid this technology. You have to embrace it. Him of all people even knew this. You can't ignore it. It will innovate around you. And that's exactly what's happening by companies going overseas. Like you said, 27 nations in the EU passed MiCA or MiCA regulations, and we may not love all of it, but you know what? They found a common ground. And to that point, James, and I know most lawyers don't like to speculate. That's not really healthy business for a lawyer, right? So, but I do know that it is interesting to me because we hear the rumblings of potential stablecoin legislation by possibly Q1 of this year. And they say if we don't get it by Q1, which is April at the latest, you're not going to see it till 2025. Do you think there's a real good chance we could see stablecoin legislation?
Well, honestly, I don't know what exactly was behind Maxine Waters' decision to kill it in the last Congress. Remember, it got very close. The word on the street was, we've got bipartisan support for this legislation. And then, you know, Maxine Waters killed it right at the end. And McHenry said that openly. So is she going to do it again? I don't know. Does it make sense that we have regulation of stable coins as kind of a first safe step forward? Yeah, it does make sense. And by the way, people in crypto want stable coins to be backed one-to-one by liquid assets. We want that. We want audits. We want proof. We want all of these things. We're not resisting this at all. Just like you and I, all of us want the frauds out of the system. Anybody who commits their time or their money, or, you know, brilliant development people, time, money, you know, whatever skills, we don't want it into a fraudulent ecosystem. We want the frauds like Sam Bankman-Fried out. That's why we want a regulatory comprehensive regulatory structure so that you can easily and quickly identify those who are operating outside of that regulatory structure and get rid of them, fine them, you know, do whatever, ban them from the industry. That's what we want. We don't want, hey, let's not have any regulation and just welcome the frauds to continue. We don't want that at all. And so it's weird that this has been set up as like anti-crypto army versus people, you know, trying to just defend financial freedom of choice. You know, there should be common ground. Hey, let's work together and get rid of the frauds. Let's work together so that when you put your money with an exchange, it's segregated and that's your money. It isn't blended with everybody else's and lent off to some hedge fund that could blow up. Let's not have that. There is plenty of room for common ground, and it's really, really frustrating that we're kind of still at square one.
Well, it is, but it does feel like, you know, the next year or so is going to be a very transformative year. I mean, I know I'm not, this is not the first time I've said that, but it does feel like we're on the edge of seeing that happen. And I want to remark, just to close on, you know, stablecoin legislation and this topic here, if we get the legislation for stable coins by Q1 of this year, It will be phenomenal. And look, I know it's the on and off ramps. It's a guaranteed backing, right? It would be in a regulatory framework, probably prudential regulation, I would imagine. And, you know, the larger part of this is if the legislation is truly clear, James, I try to impress on people to understand that it will be the reason banks can move to 24/7, 365, because
Right.
those stable coins will allow them for the first time to activate the holidays, weekends, all of it, instant movement of value. And everything will change immediately upon that legislation being done properly and passing. So I want people to understand the real impact outside of crypto, right? How that's going to affect the legacy financial system in general. What a day that's going to be. I think people still think about, you know, stable coins, they just want the on and off ramp. They're not really thinking about the impact it's going to have on the rest of the world in payments and moving value. It's going to be massive. So I hope we see it sooner rather than later.
Yeah, you know, what was interesting is Gary Cohn, who was the
Oh, yeah.
chairman of the economic advisors or something early on for Trump, came on CNBC. Now, he didn't mention stable coins, but he said, you know, with these Bitcoin ETFs coming onto the scene, people are learning that there's this asset that trades and settles immediately, you know, unlike anything else. And it could drag the entire financial system to a immediate settlement system. And he, you know, was saying this is an obvious positive because right now, you know, people aren't understanding this. When you buy a share of the Bitcoin ETF, it settles 2 days later. That means the money doesn't get to the sponsor. Settlement is the exchange of the asset for the money. It happens 2 days later. Can you imagine that? It's 2024 and it takes 2 days to settle a trade that you think happens instantly because on your screen, you're seeing it. You're seeing your money there, but it didn't. It settles 2 days later, and then they get the money. Then they go buy the Bitcoin. You know, that's not a good system with an asset that's that volatile.
Yes.
Nobody, a few people have been talking about it. I heard somebody start to talk about it yesterday. But you're right. The stable coins would solve, you know, for virtually all of this and get instantaneous settlement and 24/7 trading.
Yeah, it's a remarkable moment. If you know when it comes, it will come, right? It was just when it comes, it's going to be remarkable, and I do hope that it's sooner rather than later. All right, let's move forward now to there's the Ripple case, the Zakinov case, which I know I think you have a ton of follow up on that one, but I just want to remind people about the Zakinov case, which was really a case that was here before the SEC versus Ripple, where a gentleman named Zakinov had bought some XRP and about 2 weeks later, literally, turns around and sells it for a loss and then tries to sue Ripple for it being a security and he lost money on it, basically. And what's interesting about that case is that I'm trying to understand how is this case still alive when Judge Torres has said secondary market sales are not securities? So where the hell is this case at? Why are we still watching it unfold?
Yeah, it's really unfortunate. You know, I think you and I had this conversation some time ago, a year ago or something, about one judge making a decision is not precedent for any other judge in any other district. And while we talked about it sort of as a general proposition, my goodness, now it's playing out live and in color in California, where the judge is just ignoring the fact that this asset is not a security when traded on the secondary market. And that's what the case is about. So this case should not have proceeded. And the second thing is, I believe John Deaton attempted to get involved there and say, hey, XRP holders want nothing to do with this. The whole purpose of a class action is when a large number of people have this common interest in achieving something in court. And then instead of them having to file individual actions, they can come together and file a class action, which is more efficient and have their rights adjudicated all together. But when you have a bunch of them who want nothing to do with it, it is unsuitable for class action treatment. So it's the whole thing is a little off in how it's proceeding. And unfortunately, it's a court, I believe in California, right? That is within the Ninth Circuit Court of Appeals, which is the most liberal court of appeals, and it permits, you know, class actions to go forward. And so that court, that judge, is bound by, you know, decisions of the Ninth Circuit, which have been very liberal in terms of permitting class actions to go forward. And so it's a very different setup than you've got in the Southern District of New York, where I don't believe this case would have gotten anywhere out of the blocks. And so it's really unfortunate. And then there's all this compromise of people's privacy through discovery, trying to find out who's got XRP. You know, that's just again, acting contrary to the interests of these XRP holders who don't want anything to do with the case in the first place. And so against their will, the plaintiff's lawyer is collecting data on them. It just should not have been permitted. I disagree with this thing continuing very strongly. And unfortunately, it's a very, very liberal jurisdiction there. And I don't know how much farther this is going to go. It's very unfortunate.
It is unfortunate, and it's very odd. And you're, like you said, you know, judges don't always listen to other judges in different circuits, and this is how this works. We have to hope that the process, that's the scary part of this, James, right? Like, you have to rely on the process. And I mean, you know, we're all aware there's tons of, I'm not suggesting that everyone is corrupt in a legal system or in a government or whatever, but there is a lot of corruption. There is a lot of chits and favors, all of these things that happen. We're all human beings, right? And, you know, so you do somebody a solid and they need you to do them a solid. This is the kind of thing, nepotism, all this stuff. You know, these are very real elements. And I can only hope that as we move through this process, that we continue to see the kind of rulings that we've found so far, because they really support the idea that the SEC is out of their lane. And that is most important. Speaking of out of their lane, James, okay, another odd scenario here is that after the ruling came out with Judge Torres that XRP in and of itself is not a security, what happened in New York with the NYDFS, Jay?
Less than 2 months later, the New York Department of Financial Services came out with an update to their green list. Now, I have been complimentary of the New York Department of Financial Services for having a green list that the SEC does not have. And this green list says, if you're an exchange, you can offer these tokens to New York residents, you're good. If you want to list a new one, then you've got to go through a process with us, which again, that makes sense as well. So I've been, you know, complimentary of how it's been approached. And so XRP has been on the green list. And so after Judge Torres ruled that XRP traded on the secondary market is not a security, less than 2 months later, the New York Department of Financial Services updated their green list and withdrew XRP from the list. It's no longer green listed for residents of New York to trade in XRP on any platform that has a bit license that can operate in New York. So this struck me as kind of odd, because Gary Gensler took the loss. You and I went through it line by line, and it was a loss, and a big loss, and an embarrassing loss. And then the next thing you know, this other state regulator says, no. Now that XRP has acquired clarity that's not security, we're going to delist it. This is what we call a non sequitur. It does not follow at all. In fact, if it had not been on the green list, the decision of Judge Torres would be a reason to add it to the green list, not take it off. And so me being a semi-retired lawyer with a little time on my hands thought, you know what? I'd like to understand what exactly has happened here. This is a government servant, government agency, and we're supposed to have sunshine laws that allow citizens to understand why their government does what it does. So I sent a Freedom of Information Act to the New York Department of Financial Services immediately after that press release came out. In New York, it's called FOIL with an L instead of FOIA with an A. And it just means Freedom of Information Law. And so, and it's very, very similar to FOIA. And they have a deadline to respond. And all I said was, I would like to have every single document, slip of paper, text, voicemail, video chat, or anything else that involved the decision to delist XRP from the green list. Want all of that. Oh, and the second thing I want is all communications with any other agency of government at any level, including the federal government, or any other state or any other agency anywhere in the world, where they communicated to you about your decision about whether to delist XRP. And of course, what I was looking for there is whether the SEC had influenced this decision, because it makes no sense at all to delist when it's clearly not a security. And a federal judge in this town where you work in Manhattan said, not a security. And so anyway, I sent this Freedom of Information thing, and basically so far, I don't have any documents. So far they have missed 2 deadlines that they get to extend their own deadline. So now the next deadline is the end of this month, January 31st. And so while I am a lawyer, and I have a license to practice in New York, I've retained a lawyer who's an expert in Freedom of Information Act law cases, and I'm not going to let it go, because what was done here is quite bizarre. Perhaps, Brad, there's a rational explanation for this. I cannot think of what it might be, but I'd like to see the documents and see if, in fact, somebody put their thumb on the scale and said, look, I know this is embarrassing to take it off the list when it's clearly no longer considered a security, but we got to do it because somebody over here is applying pressure. I don't know. I don't know if there was a political consideration, but I intend to find out. And if it requires filing litigation in New York, that's what I will be doing. I
tell you, God bless you, James. I mean, that is such a, this could be a real, it could be a real bombshell what you uncover here, because look, we can't say that we know every reason they would have decided to go against green listing that. But as you said, there is no apparent reason, no obvious reason to any of us why that would have been done, unless, I love to speculate. We tend to do a bit of that here. We know that there is a bit of a hang up with that Ethereum free pass. We know that Gary Gensler has spoke out of school and said that Bitcoin was a commodity and then didn't speak to the rest of the market. We know that HODL Law, Fred Rispoli, went as far as to force the SEC to admit they had not ruled on whether Ethereum was a commodity or a security at this point. So it is unknown, right? And then we have this idea that the case comes out with XRP, it's not a security. And then there's this indirect, what appears to be an indirect push to the NYDFS to delist that. It is very odd, James.
It is odd, and it's kind of unfortunate that we live in a world now where you've got to have people like John Deaton and Judicial Watch and Empower and these, the Blockchain Association, Chamber of Digital Commerce, and all of that doing this investigation to find out what in the world is going on and why. The government is supposed to be transparent. Maybe I sound very naive at this point, but the fact that like individual citizens have to get to the bottom of stuff and then disclose it on X to everyone so that they now know what happened. Brad, I'm a little older than you, but you're old enough to remember there used to be this concept of investigative journalism where you would have actual journalists from the New York Times and the Washington Post and the AP, UPI, and Reuters getting to the bottom of stuff, and 60 Minutes used to do that. They would get to the bottom of stuff. And the fact that the New York Times, it's me instead of the New York Times saying, boy, that's kind of weird that this case was decided right here in our backyard in Manhattan, says this asset, which is an important asset with a big international use case, is not a security, and now it's delisted by the main regulator here in New York. Somebody should be assigned to get to the bottom of this. Nope, they're not in that business anymore. So it's crazy and so different from when you and I were younger, where it would be like you get the newspaper and go, holy cow, they've broken another really important case.
Oh, you're absolutely right. The whole world of journalism has been turned on its head, and there are very, very hard to find. It is a rarity to find, it is a rarity to find an investigative journalist that's truly an investigative journalist, right? And it really comes down to citizen journalists at this point where we are in this time. And that's why, look, and I know censorship's been a big issue for you. It's been a big issue for me, and we all see and experience these things happening. There's so many layers. It's not just crypto, right? There's so many layers, with the media, the social media platforms, censorship working as a third-party outsourcing arm for the government and the administration. It is, there's AI and the onset of AI to come, and replacing people's images and words in their mouthing, having it look like they really said something, but it's fake, but you can't tell. It's like the polarity of this world feels really upside down, and I know we'll get through it, but it is going to take some regulation to get through it. I know a lot of people don't like to hear that because most people are in this space because they don't want any of that, but we're not going to be able to move forward collectively in this space unless we have a clear regulation framework and legislation that allows this innovation to thrive and grow, and people can bring their money and understand what the rules are on the field, because that's why they're pouring into other countries now. They don't want to wait, right? And this is where we are. We're stuck in this quagmire, and that's one of the reasons I hope we get stablecoin legislation. Again, it'll help move us one step closer to this real integration into the traditional legacy financial system, which is so very key, because once that happens, there really is no going back. Because once they feel the effects of that, and because they've been fearful of it for so many years, for more than a decade, they've been fearful of it. But once they truly embrace it, understanding that there's only 2 or 3 of the big gatekeepers in the banking world that control cross-border payments, and the other 98% of them actually pay them to get it done. That is where things will change, because it'll be the 98% that start to take this technology up to be able to compete and do a workaround on what the system has been for so long.
Well, you're absolutely right, Brad. And you mentioned censorship. I know you've experienced it yourself. I got a quick story for you.
Yeah.
I wrote a column about how Gary Gensler, in my view, was acting contrary to the law in doing this regulation by enforcement attack on the crypto industry. And I, kind of went through some of the recent Supreme Court cases where they've reined in the Department of Education on the student loan thing, because that's Congress to decide whether there's going to be student loan forgiveness. And then the EPA decides to shut down every coal mine in the country. And the Supreme Court again said, no, the Congress gets to decide an important question like that. And so I went through all of that. And in the end, I said, I believe that the courts will eventually rein in Gary Gensler. But the question is, how much damage is he going to do in the interim before he is stopped for good by the courts? And so when the American Banker agreed to publish my column, I was surprised. I thought, this is great. I'm glad that the banking community is now going to read my column. Well, a couple of weeks ago, I get an email from the American Banker saying that I've tweeted out the story with a link to the American Banker, my column, that is a live link to the story. And they say they demand that I delete my tweet, take down the link immediately, because I am engaged in unlawful activity. So what's funny about that is, because I was surprised that they had actually run my column, which is not a point of view that is typically reflected in the American Banker, I knew that I needed to protect that column and that space. And so I bought a license to publish on social media that story, that column. And it's not like one of those things where you pay $50 for a reprint and put it on the website. I paid them $3,000 for the license to publish that column. That's how important it was. And they send me an email. And by the way, they said that this demand originated from the editorial team. That's their term. The editorial team at the American Banker was demanding that I take it down. It wasn't like the sales office or the chief operating office. The editors wanted it down, and it was critical of Gary Gensler. And I responded to them, well, yeah, I'm not taking this down. And you sold me a license. I'm using the license and people are seeing your article. You should be happy. And they came back and said, there's no evidence of you ever purchasing a license, and there's no record here of any license of any kind for you or this story. Meanwhile, I'm holding all of these emails. There are like 6 or 7 people associated with the American Banker who were involved in selling this, reprint right, this republication right to me. And so in any event, that strikes me as odd that it sounds like somebody did not like that content and were trying to intimidate me into taking it down, which of course I would not do. So in any event, there's weird stuff going on all around. I know you've experienced it. Many people who are watching this as well have experienced it in their own life, and we just need to not back down. I think is the answer.
Hey, Tom Petty, baby, I won't back down. You know what I mean? That's what I'm talking about. I love that you have this fight in you. But fight it's a calm resolve, right? You have no. That's not right, right? And what's nice is you don't get explosive, you get resolved. Like, no. I know this is not right. And then you just simply start knocking out these people don't know who they're messing with. If they're coming up against the MetaLawMan, they better watch out what the hell is going on, because you have been one of those people out in this space shining a light on so many things. I want to highlight this before we wrap too. It may have been the first time you and I sat down and spoke. You made it clear that John Deaton had forevermore changed the way crypto cases would be fought through the amicus brief filing and a class action with it. And I tell you, that has really stood the test of time, what you had said, because in all of these cases, we see amicus brief after amicus brief filings and amicus brief filings, bringing more opinions into these judges, because this is a very special moment, because we're talking about technology here. So that a lot of these judges, as you said earlier today, don't have the deep understanding about everything that's involved, all the factors that you must weigh in. So these amicus brief help become these informing things. So you're not just getting two sides of the story. So very important. And you're the one that said that. And I give you the credit, James, because I think it's so right. Every case has forevermore been changed in the crypto space the way it's challenged.
Well, 100%. And John Deaton obviously is the one who thought it up. And we emphasized when you and I talked about it at first, judges do not know what to make of this. They've never heard of this. Everyone pictures as the SEC as the advocates for the investors in something that's gone wrong, and that they are in the background cheering on the effort of the SEC. And you know what? Historically, that is exactly how they did it. And they were being cheered. Yeah, get the fraud. Get me some money back. So to have thousands of the token holders come in and say, Judge, please, the risk to what I'm doing here is the SEC itself. Please stop them. And so now in Coinbase and in Binance, but in Coinbase, there's 10 tokens, or let's take Binance, there's 13 tokens. And the judge said at the hearing, well, how are we going to try this case of whether these 13 tokens are securities when you haven't sued any of the issuers of the tokens. How's that possible? And it's a bunch of double talk, but I can tell you this, if John or somebody, it's unfortunate, John's got to do everything in this space, but if somebody comes in with token holders for thousands of token holders for each of the 13, the judge is going to be like, we're not doing this. We are not going to. So I'm saying, if this case gets past a motion to dismiss, there will be the opportunity for John or somebody to come in and do exactly the same thing. And based on what that judge said at that hearing, she will be very receptive to, we're not going to do this. We're not going, we'll have in Binance, we'll have a trial if it comes to that, of the BNB token that was issued by Binance. And that's it, I think is where she would go if somebody like John comes in and does that work.
100%. And, and shout out to John Deaton and everything he does. It's just remarkable what this guy has been doing. I don't know how he does it. I don't know what he's running on, sleep. I don't even know when this guy has time to sleep. Who knows? I mean, he's been an incredible, powerful figure since the day he showed up, and so have you. And speaking of that, we know that we're tackling all these major conversations because there's so many developments in these cases that are happening with the SEC taking up at the courts. And we understand that we're starting to see these little pictures and windows show up that are kind of, really giving us this kind of outline of where things may end up and start to get a picture of how the space could look in another 3 to 5 years. That's why I believe this year is going to be one of the most important conversations ever, and it will be happening at XRP Las Vegas. And James, I'm hoping that you will come join us at XRP Las Vegas and be on stage with us and John Deaton and others to have a very critical conversation about the legal process, the current cases, the state of where things are with crypto. What say you, my friend?
Brad, I am in for XRP Las Vegas 2. I heard so much about the first one. So much fun was had, so much learning and connection with people. And in this past year, I've gotten to know John Deaton well. I got to meet DAI as we worked our strategy to get reinstated out of the penalty box. And of course, I've learned so much from you and being on your show and watching your everything you publish. And so I'm really excited about being there. And so count me in. I'm looking forward to it.
Oh, well, we're super excited. And listen, you're going to be on stage along with Perry Ann Boring from the Chamber of Digital Commerce. And then you're going to be on stage. We got Honorable Christian Carlo, former chairman of the CFTC, co-founder of the Digital Dollar Project for the United States.
Right.
We're talking about David Schwartz, the CTO of Ripple, on stage. Look, there's so many others. The CEO of Uphold will be there. The CEO of iTrust will be there. John Deaton's going to be there. Jeremy Hogan's going to appear virtually with us. You're going to be on stage. This is going to be a don't miss event. I'm telling you, and there's more to come. I can't say it because I don't like to say it till the fish is in the boat, and it's going to be remarkable. But the fact that we got you on board is amazing. James, thank you so much.
I'm in, looking forward to it. I haven't met you in person yet, Brad, but it sounds like a fantastic time, and I will be there and really, really, really looking forward to it.
Oh, so are we. James, thank you so much. Do you have any final thoughts before we go?
No, I don't, but I just really love the enthusiasm you bring to this topic. The first time you and I were on together, I came on and said, look, I'm on here because I just got on to Twitter, and I'm amazed at the level of understanding and debate and the facts in the XRP community. And so that's what I said to you when I arrived. It's like, it's amazing that there's really a spirit of learning, and curiosity about the world and how it's going to develop in terms of our financial system and everything else. And so it's really wonderful that I've been welcomed into it a little bit, and so that's why I look so forward to meeting a lot more people in Las Vegas.
Well, you know what? We feel the same way about you, James, because like I said in the earlier conversation, you, John Deaton, James Filan, so many others, Jeremy Hogan, and so many others have been so critical in helping guide us through this process and to kind of educate us up with the, what do you call it? The cliff notes of most of these cases.
Right.
So we can kind of hang on and keep some understanding through this process. It is a ebb and flow. It goes back and forth. We appreciate you, James, and don't go away. We will talk to you off camera. Thank you so much for being here. James Murphy, MetaLawMan.
Thank you.